Well, that concludes the presentations by our four commercial lawyers, but now I've got the presentation which really matters, which is Verity Barker, who's going to tell us whether these differences that we've been talking about actually matter from a litigator's perspective. Verity.
Thank you, Jonathan.
The differences between conditions, warranties, guarantees and indemnities have already been explored by our panel in great detail. As you've heard, how the terms of the contract are drafted will, in the absence of any evidence to the contrary, or factors outside the contract, frame the remedies available. In theory then, as a litigator, I have little to add, and the way should be straightforward from here. But as you've seen from these talks, if only life were that simple in the world of common law. I'm therefore going to give you a brief overview of how the courts have approached these categorisations, how that affects the remedies available, and some litigation bear traps to avoid. From a litigator's perspective, your tactics will depend on whether you're acting for the claimant, the party which is alleging the breach of contract, or the defendant, the party which has been accused of breaching the contract. Do you want to escape the contract, or is there an ongoing commercial relationship? Is any payout due in the event of termination of the contract that you want to avoid or minimise? The amount and type of damages attached to breaches of conditions and warranties varies. It's important that the discussion regarding what terms have been or are about to be breached and how those terms can be categorised is discussed in the context of the claimant or defendant's own goal. These discussions will, depending of course on the individual factors of the breach, identify how to frame the statements of case. Alternatively, do you think that the other party is about to breach the contract and that you or your client will need interim relief or an injunction? Is the other party based abroad? Does it have any assets in the jurisdiction which you can attack? Consider whether you want to apply for security costs in the context of those proceedings, particularly where you have a defendant outside of the jurisdiction. The damages available for a claim under contract, such as a claim following a breach of warranty or breach of condition, seek to place the claimant in the same position as if the contract had been performed. Claims for pure economic loss, such as anticipated profits, are difficult to prove and rely on expert evidence, which could be costly. If there has been a breach of a condition in a contract, then the claimant will have the right to either terminate the contract or affirm the contract. In each case, the aggrieved party can also claim damages. It may be that the claimant wants to get out of the contract and will want to show that a condition has been breached. This is not straightforward because, as we've seen, although conditions do have certain characteristics which identify them and may be defined by the contract, the courts will take a purposive approach in the absence of the clear intention of the parties. As a general rule, if the parties expressly identify the term as a condition or a warranty, the courts will treat it as such, unless there are overriding factors to the contrary. If a term can be breached in a way which will only cause a limited loss, and therefore not be material to the contract, the court may hold that such a breach will not justify termination, even though the term is called a condition. By way of example, in Wickham Limited versus Schuller AG, the House of Lords, as was then, considered a contract between Schuller, a German company which manufactured panel presses, and Wickham Machine Tool Sales, an English company which had the sole right to sell Schuller products in the UK. The agreement specified that it was a condition of the agreement that Wickham's agents visited the 6 named car showrooms at least every week. Wickham's agents failed to make any visits at the start, and this was initially waived by Schuller, but then the agents made some, but not all of the visits, and Schuller terminated the contract on this basis. Wickham sued for breach of contract. The House of Lords was not convinced that the parties intended to use the word in its legal technical meaning. It recognised that there was a presumption that if the word condition was used in a formal contract, it indicated that a breach of that term, however small, would give right to the right to repudiate. However, on these facts, the construction produced a result so unreasonable that the parties could not have intended it. Therefore, I would echo the drafting recommendations made earlier, that the clause expressly states what rights will be available on breach. Similarly, from a drafting perspective, be careful not to implicitly exclude the common law modes of exit from a contract if that's not your intention. Where there is no evidence of the party's intention, the courts will look at the commercial importance of the terms. Courts want to restrict the right to terminate to cases where the breach causes serious prejudice to the injured party, and to prevent parties from terminating for ulterior motives, such as escaping an unwelcome bargain. However, if it is established that a condition has been breached, the claimant may nevertheless want the contract to continue. In this case, the claimant can affirm the contract. It's very important that the party does not waive the decision to terminate if that's not what they intend. Parties should be very careful about not acting in a way which shows continued performance of the contract, for example, by accepting rent under a lease. You should bear in mind that once a party has affirmed the contract, the affirmation is irrevocable unless there are further breaches. This is in contrast with a breach of warranty, where there's no right to treat the contract as discharged, as with a breach of condition, and only a right to claim damages. Aside from the claim in contract, the claimant should also look at whether they have a claim in tort, for example, by way of a claim for negligent misrepresentation, as outlined by Alex. The damages for a claim in tort seek to put the claimant in the same financial position he would have been in if the tort had not been committed. The damages in tort are subject to the principle of remoteness, causation and mitigation. As Alex has covered, there may also be a third option, where there are representations which have been incorporated into the terms of the contract. The remedies in case of a breach of representation can potentially give rise to tortious damage, say for negligent misrepresentation under the Misrepresentation Act, where you can show reliance. This could be a helpful option, where tortious damages would be preferable to contractual compensation. In each case, an exercise to calculate the potential available damages under each head should be calculated. Depending on the facts of the case, this could determine whether to bring the primary claim in contract or tort. Your negotiating position will be strengthened if the contractual clauses are specific about what remedies will be available on a breach, and what types of damages are contemplated. A liquidated damages clause will avoid the need to prove loss or remoteness of damage. A liquidated damages clause will be unenforceable if it's punitive, but provides reduced litigation risk if it's a genuine pre-estimate of the loss likely to be caused by the breach. Both parties will have a fixed starting point for their negotiations. Specific performance might also be appropriate, and it's an equitable remedy available for a breach of contract, whereby the court issues an order requiring a party to perform that part of their obligation which remains underperformed. In the High Court, it may be granted in addition to or instead of damages. It's a discretionary remedy, only available where the subject matter of the contract is unique, such as, I would suggest, the completion of the Olympic 2012 Aquatic Centre, and would not be available if damages are a sufficient remedy. The courts are unlikely to order specific performance in certain types of contracts, and more likely in others. For example, specific performance is not usually available if performance of the contract requires constant supervision over a period of time, and the obligations of the contract are not clearly defined. Similarly, it would only be granted in contracts for personal services, such as employment contracts, in exceptional circumstances. You more often see specific performance ordered in relation to building contracts. Such contracts usually define the work to be completed with some certainty and deal with the results rather than carrying on an activity over a period of time. The court has a broad discretion to award specific performance, and in exercising that discretion it takes into account factors such as the following. If there's a risk of insolvency of the defendant, the court will be more likely to make an order for specific performance because the claimant would not be adequately compensated for any loss caused by the breach of contract if the defendant was to become insolvent. The court will not award specific performance if the defendant can show that it would be impossible for it to complete the contract. The defendants in Matilla Limited and Machine Properties have been unable to complete the contracts because of lack of additional finance. However, the onus is on the defendant to provide the fullest possible disclosure to show that it was impossible and not just difficult for them to perform the contract. And finally, the court will look at any unreasonable delay. The court's unlikely to award specific performance where there's been unreasonable delay or the claimant has not provided its own side of the bargain. It will also have in mind the ultimate balance between the cost-benefit to both parties. Other equitable remedies are potentially available, such as injunctions, freezing orders, search orders, or an account of profits claim. Those remedies are separate topics in themselves, but just to highlight that, as with specific performance, an injunction will not be granted if damages is an inadequate remedy, and they can be expensive to obtain. Freezing orders and search orders are usually only relevant in the context of fraud and a clear risk of dissipation of assets and destruction of evidence. As a claimant, you should also look to see whether there are any guarantees or indemnities in place under which you can also claim. Jonathan has explained the characteristics of an indemnity and guarantee. From a litigator's perspective, an indemnity is more robust than a guarantee because guarantees will be unenforceable if the primary obligation ceases to exist. It should also give a clear framework to the negotiations between the parties. It may also be worth digressing slightly to consider the US position, where the use of an indemnity to support a breach of contract is more common, because in the US there is no loser pay principle in court litigation, and the claimant would not normally be awarded his costs in addition to a damages award, and so the indemnity wording is intended to extend the scope of the claimant's right to recover. This issue doesn't arise under English law to the same extent, as a successful claimant should benefit from a costs award as well as a damages award, although of course in the UK legal costs are rarely recovered in full, and so a party in a strong negotiating position should try for a specific indemnity against all legal costs, whether or not they would otherwise be awarded by a court. In a recent case between AstraZeneca and IBM, the court awarded costs to be assessed on the indemnity basis, following the provision for costs in the contract. AstraZeneca relied on a clause that provided that IBM would indemnify it against defence costs incurred in connection with any dispute in which judgment was given in its favour.